Who is liable when a dog bites in Maryland? Understanding Maryland's strict liability law for dog bites. You probably think your dog's never bitten anyone, so you'd never be held responsible if it did. But in Maryland, that is not how it works. One bite, even the first bite, can make you legally and financially liable no matter how gentle your dog has always been. And most owners don't find out about that until it's too late. This video breaks down Maryland's strict liability dog bite law, what counts as a bite, when the law applies, and how to protect yourself before a single incident turns into a lawsuit. So whether you're a dog owner or someone who's been bitten, you'll know exactly where you stand under Maryland law. Hi, I'm Bobby Zirkin. I've been a personal injury attorney for close to 30 years. And let's get right to the heart of what Maryland's strict liability law means for dog bites. In our state, if a dog bites someone, the owner can be held responsible, even if they had no idea that their dog was dangerous, or even if the dog had never bitten before. Many people I talk to don't realize just how serious that is. This isn't just about bad dogs or bad owners. It's about making sure that people who suffer injuries get help, and that dog owners are aware of the real risks under Maryland law. So what does strict liability mean in Maryland dog bite cases? Strict liability means that after a dog bite, the owner is on the hook for damages no matter how careful they were or how nice the dog has always been. The injured person doesn't have to prove that the owner was careless or that the owner failed to stop their dog. It's enough to prove just two things. First, that the dog bit or injured a person, and second, that the dog was running at large when that dog injured the individual. Let me give you a quick example. Imagine you're walking down the street in Baltimore and a dog escapes a gate, runs up, and bites you on the leg. Even if the owner swears that the dog has never been aggressive before, Maryland law says that the owner is responsible for your injuries. It's called strict liability. There are exceptions to the strict liability law in Maryland. Not every bite automatically gets the person compensated. First, if the person who was bitten was trespassing, meaning they were somewhere they didn't have a right to be, like sneaking into a fenced backyard. Second, the person provoked or teased the dog immediately before the bite. If a grown adult, for example, is poking or hitting a dog and gets bitten, the law recognizes that as a provocation, and that's a defense even to strict liability. Here's a quick real-world scenario. Suppose a neighbor climbs over your fence without permission to retrieve a ball and the dog bites them. In that situation, strict liability may not apply because that individual was trespassing. Of course, there are special considerations for children, and if the case involves a young child, the law often gives them more protection. But the general principle is that you aren't strictly liable if someone is bitten while trespassing or provoking the dog. How Maryland law has changed and why it matters now. Before 2014, Maryland's dog bite law was a patchwork of cases. There was called inartfully the one free bite rule, meaning that sometimes owners only were held liable if the dog had already bitten someone before or had shown a vicious propensity in the past. That led to a lot of confusion and, quite frankly, in my opinion, injustice for bite victims. But a landmark change in 2014 made it clear. Maryland is a strict liability state for dog bites when that dog is running at large. Other than that, the presumption is that the dog has a vicious propensity. That presumption can be overcome by the defendant. It's no longer the plaintiff's responsibility to prove that the dog had a vicious past. Now, if the dog is not running at large, the plaintiff can still win that case. It's the defendant's burden to prove that their dog never did anything before and that they were not on notice. It seems like a subtle change in the law, but it's made a huge difference. This has made recovery much more predictable for people who got bitten. It also means dog owners need to be much more aware of their responsibilities. It doesn't matter if your dog's never shown aggression. You're on the hook for any damage they cause by biting someone if that dog is running at large when they injure the individual. What counts as a bite under Maryland law? It might sound obvious, but this comes up more than you would think. In Maryland, a bite typically means that the dog's mouth closes on a person, breaks the skin, or otherwise causes injury. It could be a nip, a snap that punctures the skin, or a more serious attack. The severity doesn't change liability. Even a minor bite counts. But also, any injury that a dog causes counts. It doesn't have to be a bite. So if a dog comes running and pushes you over and you're injured, that counts under the dog liability statute as well. Let's say you're at a friend's barbecue in Montgomery County. The host dog gets startled, turns, and nips your hand, leaving a small cut. That's still a bite under Maryland law. The owner is responsible, even if it was just a reflex from the dog and they apologized immediately. If the dog was running at large, it's strict liability. Other than that, it's a case based on negligence. What damages can dog bite victims recover in Maryland? The law allows victims to recover a wide range of damages, not just doctor's bills. For example, you can get medical costs, ambulance rides, any cost of stitching, antibiotics, surgeries, physical therapy. You can recover lost wages. If you miss work while healing, you can ask for lost wages as well. And then there's pain and suffering. This includes the real pain, trauma, and fear that often comes from a dog attack. Scarring and disfigurement. Maryland law recognizes that scarring, especially visible scars, are serious injuries. To make this real, picture someone bitten on the face by a neighbor's dog. Beyond medical bills, there might be surgery, therapy, years of dealing with the emotional fallout. The law gives you the right to be made as whole as possible from such a traumatic event. What to do if you are bitten by a dog in Maryland? If you or someone you love is ever bitten, the most important thing is your health. Get medical attention right away. Even a small bite can turn dangerous if it's not cleaned up properly, and you will need proof of your injuries later on. In addition, you'll want to know if the dog is up to date on its rabies shots and vaccines. This is incredibly important and it's very timely. Next, if you're able, document everything. Take photos of your injuries as soon as you can. Write down exactly what happened while it's fresh in your mind. Get the dog owner's name, contact information, and collect names of any witnesses to the occurrence. It's also important to report the bite to your local animal control or police. Not only does this create a record, but it also helps prevent others from getting bitten subsequently. How insurance works in Maryland dog bite cases. Most dog bite claims are paid by homeowners or renters insurance, not out of the owner's own pocket. If the bite happened at someone's home, their insurance may cover your medical bills, lost wages, pain and suffering, all the damages we talked about. Let's say you're at a family gathering in Prince George's County and your cousin's dog bites your arm. Even if your cousin is devastated and wants to help, it's likely their insurance will handle their claim. This is why it's so important for dog owners in Maryland to check with their insurance company to make sure they have coverage for dog bites and to know if there are any exclusions for certain breeds. What if the dog has never bitten someone before? Remember, in Maryland, strict liability means that under certain circumstances, it does not matter whether the dog has ever bitten or been aggressive before. The one free bite rule does not protect the owner when that dog is running at large. It's important to understand that. Here's an example. A friendly golden retriever at a park gets startled and bites a jogger. The owner says he's never bitten anyone before. That doesn't matter under Maryland law because the dog was running off leash and at large. Under that scenario, the owner will have to pay for the injuries unless one of the very specific exceptions apply. The role of negligence in Maryland dog bite claims. When strict liability doesn't apply, so for example, if the dog is not running at large, you go into somebody's home and the dog bites you inside of their home, or a dog is being walked on a leash and reaches out and bites you, that is when you'll have to make a claim for negligence. Negligence, as I said before, it used to be under Maryland law that the plaintiff would have to go into court and prove that the owner of the dog knew or should have known of the vicious propensities of the dog in order to show negligence, or that they were careless in some other way. That's no longer the case. After the state legislature changed the statute back in 2014, the new law shifted the burden from the plaintiff to the defendant, meaning that the owner of the dog now has to go into court and prove that they did not know anything about the vicious propensity of the dog prior to its biting the victim. And that decision always goes to the jury. It no longer can go to a judge who can rule before the jury has an opportunity to make its voice heard. So the negligence statute has changed dramatically since 2014, making it much easier for victims to be compensated in dog bite cases. Protecting yourself as a dog owner in Maryland. If you own a dog, Maryland law puts a big responsibility on your shoulders. Here's what you should do. Always secure your dog, especially in a public place or if you have visitors at your home. Warn guests if your dog is nervous or uncomfortable around strangers. Make sure your fence or leash is in good condition and used properly. Talk to your insurance agent about your policy and confirm that you have proper coverage for dog bites and that they are not excluding your specific breed of dog. Even the best trained dogs can react in surprising ways, and one bite can lead to thousands of dollars in damages, lawsuits, and heartbreak. Common misunderstandings about Maryland's dog bite law. A lot of clients come to me after hearing the wrong information about dog bites. Let's clear up some of the most common myths. Someone says, "My dog never bit anyone before, so I can't get in trouble." False. Strict liability under certain circumstances, such as running at large, means the first bite does count. If the dog just nipped, it's not a big deal. False. Any injury, including ones that don't include bites, can trigger negligence claims or strict liability if the dog was running at large. I've heard it's my friend who got bit, so they won't sue me. Often it's the insurance company who pays, not them personally. If the individual has renters or homeowners insurance, they will be the ones who are held responsible for bites. I can't be held responsible if the dog escapes without it being my fault. That's false. The law still applies, even if the dog slipped through a hole you didn't know about. You are strictly liable if the dog is running at large. How an attorney can help in Maryland dog bite cases. When a dog bite happens, emotions run high, fear, guilt, anger. A personal injury attorney can help make sense of the chaos. Whether you are the injured person or the dog owner, a lawyer can gather evidence and interview witnesses, work with doctors to document the full extent of the injury, handle insurance company negotiations so you're not pressured to settle for less than you deserve, and of course can help guide you through Maryland's strict deadlines for filing a claim in the litigation process. If you or your child has been bitten, please don't wait. Getting advice early protects your rights and your recovery. Now you know Maryland's strict liability law and negligent law for dog bites and what they mean for dog owners and victims alike. Remember that even for a first-time bite, even if it's their beloved family pet, you can be held responsible for a bite. We talked about what counts as a bite, what exceptions might apply, how insurance works, and what victims can recover. And if you own a dog, now's the time to make sure that you are protected and informed and doing everything safely to ensure that you are never a part of this. Your next watch video is Diminished Value Claim, recovering insurance money after a car accident. If you've ever been hit and your car lost value, you can get your money back, but only if you know how. Don't leave money on the table. Check to watch now and protect your rights. See you right there.